Hi, I'm Samantha. I'm with the Spiggle Law Firm, and one of the things that I'm doing a lot of right now is separation agreements, and I find these to be interesting. One thing that I always tell my clients is that you're not entitled to a separation agreement or severance package unless it's expressly detailed in your employment contract. What are you seeing, Mike, when you're doing these things as well?
Yeah, thank you, Samantha. What I'm seeing with severances, or as you said, they're not guaranteed unless there is language in a contract stating them. So they're something that you'd have to negotiate with, like an employment attorney, with your employer. But from what I've seen in my practice is that if employers and employees are in a situation in which an employee feels they've been discriminated against or retaliated against, and they are willing to separate from their employer and looking at a separation agreement, employers are usually more open to severance agreements in my experience, because it allows for a more conclusive separation between like an employer and an employee, and it can set specifically maybe how many months that employee is going to be paid a part of severance. And also, employers, maybe rightly or wrongly, believe that if they pay a lump sum to an employee who continues to work for them, they might think that employee has a sense of being untouchable or entitled, which is not true. You can always have a settlement with your employer and then still be discriminated against and have additional claims. But in my experience, if employees are willing to discuss a separation agreement with their employer, a severance is a good idea, because it might facilitate a conversation between both parties, because then you can kind of set the terms of the severance, like for amounts or things. And there's both monetary and non-monetary aspects of a severance. I don't know if you'd want to discuss that.
Well, one of the things about a severance agreement, some severance agreements are better than others. I've seen agreements where, for instance, you get paid out a full year of your salary, which is awesome. Mm-hmm. In addition to that, you can also get a bonus, and most of my clients, they love that. But the thing about bonuses, you have to be very careful. They're hard to calculate, but we always tell our clients, if you're entitled to a bonus, please, let's try to get you a bonus. And the other thing that I find in these severance agreements is non-compete clauses. Virginia just passed a law where they're restricting the scope of these non-compete clauses, because what can happen is after you leave that employment, you're looking for a new job, but you have to be careful where you can go, what you can do. So you have to get an attorney. Please get an attorney to review these severance agreements with you to make sure that these non-compete clauses are not too onerous. What are you saying in terms of?
Yeah, well, for non-compete clauses, that's a great thing to bring up. I can dive a little bit more into that. But the criteria for how I believe Virginia and other courts look at these non-compete clauses, they look as if they provide an undue burden on an employee's ability to make a living. So if you work in a very niche industry and a non-compete doesn't allow you to work in that industry, and it's not defined about who you can work for or what services you can provide, that can be an undue burden, and that can make that non-compete unenforceable before a judge. As well, non-competes need to be narrowly tailored for the interest of that company. So a lot of times that might involve like a time restriction, saying that you can't work for a competitor for 6 months or 12 months, or you also can't work for a competitor within a geographic region. So if you can't work for a competitor within maybe 2 or 3 miles from the employer that you worked for. So those are the things you kind of look for in those non-competes, because it needs to be narrowly tailored to serve the interests of the employer, and also not unduly burdensome on the employee in order for it to be actionable and to be enforceable. So as like Samantha said, if there is a severance you're dealing with and there is a non-compete or non-solicitation agreement, we encourage you to hire an employment attorney to look at that, because you might look at the language and say that it's too vague, and then an employment attorney can determine whether or not a judge or a court will actually find that agreement enforceable or not, and that can be a large deal about your severance agreements when looking at those.
One of the things that I'm finding with these severance agreements, they tend to be inequitable, meaning, for instance, remedies. It'll be one-sided. For instance, if there's a breach of these contracts, the employer, for instance, he can seek injunctions, he can get monetary awards, but our clients, they come to us and they're not afforded these same remedies or these same options. So what I always tell my client is, let's make this thing as equitable as possible. So we talk about remedies, we talk about arbitration, we talk about a whole list of items that's contained in that severance that's unequal to opportunities for our clients.
Yeah, and I think that could include like mutual non-disparagement agreements, or like other non-monetary terms, like a neutral reference for the employee, in which the employer, after the separation, the employer will state, when asked by a prospective employer looking at that client's resume, the employer will say that the client worked there for a certain period of time, this is their position, but that's essentially it. And as Samantha said, you want to have as much equitable language, if that's not mutual non-disparagement agreements or mutual like confidentiality agreements about the severance agreement, that's what you want to look for in those agreements as well.